Can I just say something about Andrea?
We got the ruling on Mickey Stines' motion to disqualify the trial court judge. It's been a while. It's kind of the evergreen observation in this case. Kind of been a while since anything happened. And so the last time I talked about this case was back when he filed this motion. And you'll recall I had a pretty dim view of its prospects. Now, it seems that it was based at least in part on some factual matters that were submitted in camera. They were not put in the public filings for us to be able to fully evaluate. But nevertheless, to me, it kind of looked like a situation where the judge sat next to Judge Mullins a week before Judge Mullins was shot by Mickey Stines at a judicial conference of some type. And so didn't really seem to suggest the kind of just inappropriately close or personal or certainly like financially vested or something like that type of interest that's typically required to justify a disqualification of a judge in circumstances like this. So it went up originally on Mickey Stines' request to the Kentucky Supreme Court, who declined to be the first to rule on it. They basically said, take it to the trial judge first. It's not our job to kind of decide this in the first instance. And then depending on what the trial judge decides, you may or may not have the option to appeal further at that point. And so that's now the point where we're at. The trial court has made his decision and he has denied Mickey Stines' motion to disqualify. So we are turning back once again to our fine friends at MountainTop Media, just doing the great legal journalism here, complete with the documents and everything. But they're giving us first the general overview. So first, this is our new trial judge. This is Judge Coron, who has been specially appointed for the case. And they just give us the outline. He has denied it. And so back in December is when they filed it based on information that these judges sat next to each other at a judicial conference just 7 days before Mullins' death. But on Friday, Coron denied the motion and vouched for his impartiality. To be sure, we shared the legal profession and may in that regard be viewed as colleagues, but our nominal, purely professional association is not the degree of relationship which would interfere with my duty to uphold and apply the law and to perform judicial duties fairly and impartially or suggest an appearance of partiality. And then just procedurally, a little bit of the background here. Back in January, the Supreme Court declined to step into the case, leaving the matter for him to decide. But the High Court left the door open for the defense to appeal if Coron elected to remain on the case. And because they're so awesome, here is our full copy of the court order. So first off, is this, yeah, this is big enough. We'll just go ahead and look at it in the page here. So I haven't read the entire order yet. We're going to just read through this together and see what the judge has to say, what his reasoning is. First thing I noticed, 13 pages, not super long, not super short. So well, let's just see what we have here. This was filed about a week ago when I was down in California, so we're playing catch up. But it's Mickey Stines. Like, delay is kind of inherent in this case, which I guess before we get too far is kind of my first thought. Well, we'll get to that after we read the brief, because we'll want to talk about the possibility of appeal and prospects and what that looks like and so forth. So this matter is before the court on the defendant Sean M. Stines' verified motion to recuse/disqualify. The defendant asserts that my impartiality in deciding a prior motion and in pending and future proceedings might reasonably be questioned. The argument is based on my attendance at a professional meeting, a meeting in which the victim in this case participated. As I have no personal bias or prejudice concerning a party, and there are no surrounding facts and circumstances upon which an objective observer might reasonably question my impartiality, the motion is denied. So now we have the background. Little footnote there for the procedure. This is what happened. It was remanded to the court for its own consideration by the Kentucky Supreme Court. In the underlying criminal case, the defendant is charged with murdering then Letcher County District Judge Kevin Mullins. Judge Mullins and I served on the Kentucky Judicial Commission on Mental Health. He's got a little footnote here that says, although they don't have to participate in these types of things, judges are encouraged to participate in activities that promote public understanding of and confidence in the judicial system. The KJCMH focus is on mental health, substance use, and intellectual disabilities, and works to improve the practice, quality, and timeliness of judicial response to cases involving these needs. The commission membership includes representatives from the judicial and legal communities, the juvenile, criminal, and child protection systems, the legislature, the business community, organizations with a substantial interest in mental health matters, and other state and local leaders who have demonstrated a commitment to mental health issues affecting Kentuckians. So he's got a citation there to the website of this commission. As of June 2025, over 75 individuals are appointed to serve as members of the KJCMH. On September 12th, 2024, 7 days before Judge Mullins was shot and killed, the KJCMH held a quarterly meeting. The 2-hour meeting was videotaped. The video serves as the basis for the defendant's motion. The video is available for viewing online. Well, we absolutely are going to copy that link, aren't we? There it is. I don't necessarily want to watch it right now, but perhaps we'll come back to that. So here we are. The video shows the undersigned judge walking into the ongoing meeting and leaving an empty chair between, taking a seat beside Judge Mullins. As the camera trained on members giving reports, Judge Mullins and I are shown on the video at various intervals. Judge Mullins gave a report in the last 20 minutes of the meeting. The video shows the undersigned listening to the report. When Judge Mullins praised a well-known program striving to prevent substance abuse and misuse and facilitate recovery, I nodded and spoke with the member to my left. I appear to nod again when Judge Mullins described a program involving him and scheduled at the upcoming District Judges College, a program about the intersection between the court system and the behavioral health system. As described in the motion, the defendant's factual basis for my disqualification is that the video shows the undersigned and Judge Mullins sitting inches apart for approximately 2 hours at the KJCMH meeting. And when Judge Mullins discussed the upcoming District Judges College, the undersigned appeared to nod in approval. The defendant views the gesture as a sharing of accolades. The defendant also contends that there is inherent bias reflected in the video, which would leave an objective observer to believe that a prior ruling, the denial of the defendant's motion to unseal the KCPC report, that was his psychological evaluation, was a result of such bias. He wanted to revisit bail, just to get us all kind of recontextualized here. He wanted to revisit bail. He wanted to rely on his psychological evaluation in support of that. The judge denied that because the psychological evaluation is confidential as a matter of statute. So now he has moved to disqualify the judge, and that means that we are waiting. There can't be any further proceedings on the bail motion until the issue with the judge gets sorted, because if the judge can't hear it, then you can't have that motion. So this all has to be resolved before they can get back to the question of should Mickey Stines be entitled to some kind of bail. So just a thing to bear in mind as we're kind of thinking about the process going forward and the strategy that's driving it. What are the priorities and so forth? Clearly, at this point, their view is that removing the judge is more important than the prospect of some bail being set. Now, perhaps they anticipate that whatever bail is ultimately set, because I do think he probably is entitled to some bail. I've talked about it a little bit in the past. I do think he's probably entitled to bail, but it doesn't mean he's going to be able to meet it. If they set a $5 million bail or something like that, that's going to be hard for most people to be able to come up with. So it may just be that they don't think there's a great prospect for him actually getting released from jail in the first place, to be kind of pushing that at the expense of this. But I think that's going to be one of the things that we'll find out from his decision on whether they appeal this or not, because appealing it is absolutely going to kick the can much, much, much further down the road. He's going to sit in the meantime, no bail, no prospect of being released. So if they choose to appeal, it seems to suggest that they don't necessarily expect he's likely to be quickly released, even if bail is set anyway. Judicial duty and standard for recusal. A judge shall uphold and apply the law and shall perform all duties of judicial office fairly and impartially. These are presumably derived from different parts of the statute. Yes. This is an interesting one. Impartial, impartiality, and impartially mean absence of bias or prejudice in favor of or against particular parties or classes of parties, as well as maintenance of an open mind in considering issues that may come before a judge. This is really getting to the heart of the difference between having some kind of prior knowledge, which happens in every single small community, where people always run into the same people over and over and over again, and being biased, where you have pre-decided things, meaning you are resistant to new information. New facts aren't going to be able to sway your opinion. And that's why it's bias in particular that is so insidious in the court process with judges and so forth, because if they're not receptive to the information, then you're not really getting a fair trial based on the evidence. You're getting a trial based on the judge's preconceptions. And those preconceptions could be based on all types of different things. They could be based on your classic examples, racial bias, gender bias, stuff like that. Oh, women don't lie. Therefore, here's the outcome. Police don't lie. Therefore, here's the outcome. And so in a case like that, if you present evidence of the police officer lying and you have a biased judge, it's not going to matter. They're going to find a way to reason around it, or, just suggest that your basis for saying that isn't credible, or, absolute worst case scenario, even if it is, even if the police officer did lie, then it doesn't matter because. So that's bias. But pre-knowledge, knowing people, even having opinions about them and thoughts and ideas about, is this person a good lawyer? Is this person generally honest? These things are not inherently disqualifying. They are normal and human. Judges are not required to live in a castle, in an ivory tower, separate and apart from society. There is maybe a little bit of a kind of romantic old time view of like some of these old school judges. I remember a video I did way back on Standing Bear's writ. The judge in that particular case, I can't remember his name now off the top of my head, but I remember there's like some background about this particular judge, and he was kind of that type, not a real social butterfly. He liked to be out hunting on his own, and there was a whole issue with getting the writ served in time. They had to like find the judge wherever he was out hunting to be able to get him the writ, because if they didn't, then there was a risk that the president was going to act more quickly to get the army mobilized so that Standing Bear would be taken back to the Oklahoma reservation. So, it's not like judges like that don't exist, but it's not a job requirement. It's just is maybe a kind of personal characteristic that might be helpful, might be beneficial, be a little bit of a lone wolf. But no, that's not probably even close to the majority of judges. Judges, especially in this day and age, they are political. It's a political position. You get in because you are elected by somebody who is, influential, appointed by somebody influential, or you are elected by the populace. And so you have engaged in the whole political process yourself, the things that you have to do to get elected. You have to join organizations, you have to sit on boards, you have to, do all of this networking type of stuff to be able to get in that position in the first place. And so it's not realistic, and nor would it be a good thing for judges to just sort of do those for purposes of their resume and then just abandon them as soon as they get to the bench. So judges are expected to have relationships, communications, thoughts, ideas, and so forth. They just have to have an open mind. They have to be willing to consider, my impression about this guy might have been way off based on this new information that I'm now receiving. And so it's only when they're not able to do that that disqualification is really necessary. And that's why there are certain types of relationships where the law presumes they aren't going to be able to do that. If your pocketbook, your money is tied to that guy and how he does in court, presumed you can't put that aside. If this is somebody that is of the type of relationship that is so close to you that you can't be expected to be impartial about it, like, sorry, people aren't impartial about their parents, their siblings, their spouse. But can you be impartial about, a nephew, a cousin? You're getting far more likely. Far more likely. So I like this description here because to me it really does get to the core of what this nuance is, the difference between, as I say a million times, being biased and being informed. When you're informed, you have information and you have opinions based on it because you're human and that's how human brains process information. But if you are still receptive to new information, you're not biased. If you are willing to update your worldview, you are not biased. You are merely informed. In other words, absent good cause for recusal, judges have an obligation to remain on and decide a given case. It is their duty. It's not something to do just willy-nilly to get out of a case. Oh, this one looks difficult. I got an excuse. I'm gonna nope on out of it. That's really not consistent with the public service aspect of these types of roles. Had a very same attitude in public defense, in pretty much every place I ever worked. You don't just nope out because you don't like this client, or it looks a little bit difficult or things like that. It's your responsibility. It's your duty that you've taken on. And so you need to be pretty sure that this is a situation that requires you to get out before you do that. So we have a rule with commentary that explains judges must be available to decide the matters that come before the court. Although there are times when disqualification is necessary to protect the rights of litigants and preserve public confidence in the independence, integrity, and impartiality of the judiciary, judges must be available to decide matters that come before the courts. Unwarranted disqualification may bring public disfavor to the court and to the judge personally. The dignity of the court, the judge's respect for fulfillment of judicial duties, and a proper concern for the burdens that may be imposed upon the judge's colleagues require that a judge not use disqualification to avoid cases that present difficult, controversial, or unpopular issues. Nobody wants to be on a team with that guy, the guy that won't do the hard job when it's his turn and he just dumps it off on other people. Nobody wants that. And then you have this whole side of like, yeah, what's it look like if you have a judge who just decides, nah, I don't think I'm going to hear this case. I'm going to let somebody else handle it. The judge that nopes out of a whole bunch of his cases, it says something, I mean, obviously just about his own kind of work ethic and sense of responsibility and so forth. But it also starts to raise questions about why are you getting out of these cases and not the other ones? It already kind of tends to imply some type of prejudgment or opinion about the case, simply by virtue of the fact that you're choosing to stay on it. Must mean it's not real complicated. Must mean it's not real difficult. So it's not just a straightforward, no harm type of thing for a judge to step aside from that responsibility and say he's unqualified to be able to serve in that position. So these various provisions here contain the rules related to disqualification of a judge from a proceeding. While KRS 26A020 speaks in terms of a party's complaint that, quote, the judge will not afford him a fair and impartial trial, unquote, these two other provisions describe in more detail the circumstances in which a judge must disqualify himself. Rule 2.11A1 states, a judge shall disqualify himself or herself in any proceeding in which the judge's impartiality might reasonably be questioned, including but not limited to the following circumstances. The judge has a personal bias or prejudice concerning a party or a party's lawyer. There's this footnote here. It's just referring us to other notes. KRS 26A.0152, similarly in pertinent part, states, any judge of the Court of Justice shall disqualify himself in any proceeding, A, where he has a personal bias or prejudice concerning a party, E, where he has a knowledge of any other circumstances in which his impartiality might reasonably be questioned. The goal of the provision that a judge is required to disqualify from a proceeding in which the judge's impartiality might reasonably be questioned is to avoid even the appearance of partiality so as to promote public confidence in the integrity of the judicial process. The motion to recuse requires an accompanying affidavit setting forth factual allegations. There must be a showing of facts of a character calculated seriously to impair the judge's impartiality and sway his judgment. So it's not that he has to be like absolutely biased, I'm completely closed off. It sounds like a mere resistance to new information would be good enough. That's really what partiality is. That's kind of the difference between I'm partial to this person and I'm biased in favor of this person. Partial toward them, I'm going to be inclined to believe what they have to say. And so I'm going to be more likely to question or be suspicious of evidence that's presented to me that contradicts that prior assumption. So a little bit less than complete resistance, but indicating less than a full openness. Somewhere in that middle ground is where we have the impartiality. There must be evidence drawing the judge's impartiality into question. Stated another way, the standards governing disqualification of a judge require a showing of more than a party's mere belief that the judge will not afford a fair and impartial trial. The standard for determining whether a judge's impartiality might reasonably be questioned is an objective one. That is, whether a judge's impartiality might reasonably be questioned from the perspective of a reasonable observer who is informed of all the surrounding facts and circumstances. Into our analysis. The defendant acknowledges that the fact the undersigned and Judge Mullins served on the KJCMH committee is not enough to draw an objectively reasonable inference of partiality. And he meant to say impartiality. That's fine. Or he said impartiality, but means the other. The defendant believes, however, that timing of events and my close seating to Judge Mullins at the KJCMH meeting created a circumstance which requires my recusal. It's a pretty fine line they're trying to draw here, where just being on the committee isn't enough, but somehow sitting next to the judge at the committee meeting is. To the extent there's additional information in the stuff that was reviewed in camera, doesn't really seem to be playing a part in the thought process so far. So seems like perhaps it doesn't add anything to it. Just really not clear. The defendant asserts that had the KJCMH video been taken months prior to the defendant shooting the victim, an appearance of propriety would not be so concerning. However, he contends the video creates an impression to the public that there is a bias on my part in favor of my colleague seated next to me. The defendant also states that it is difficult to understand how the undersigned's close proximity with Judge Mullins, both time and distance, would not lead the reasonable observer to impute a bias in favor of disbelief of negative statements about Judge Mullins and the propensity to disallow the same. There's like a group, a commission of 75 people, and one of them there is one you know from other circumstances. Professionally, you're familiar with each other. Maybe you've talked before. Maybe you've run into each other in judge-related settings. Isn't it kind of normal to gravitate towards the people that you know in a group like this? Isn't that really expected? It doesn't even necessarily mean that you particularly like this person or have any opinions about them at all. It means they're familiar. To me, this seems really unremarkable. I know that a lot of folks disagreed with me when I did my first video on this, and I think probably a lot of the reason for that is because these rules are still operating out of a framework where it's expected and assumed that we trust these people in these roles to be principled, to follow these ethical limitations and so forth. And we may be in an era today that is too cynical for these types of rules to really resonate. They don't necessarily make a lot of sense. The solution to that is going to be to change the rules. And that's our kind of classic positivist approach. We're not asking what the law should be vis-a-vis judge disqualifications. We're asking what it is. And what it is we trust the judges to evaluate kind of for themselves if we're in a context where they're going to have a hard time disbelieving information that contradicts their priors. And other than the limited situations where we presume they're unable to do that because of the nature of the relationship, they get a lot of trust to be able to make that decision. So can be overcome. Sure, it can be overcome. You can show, hey, these guys play poker together every weekend and they drink socially and they're a part of a chat group and they talk about, highly personal things. Like you can bring up facts if you think the judge is not, fairly exercising his judgment in that regard. But you got to have the facts. And, sitting next to the person that you know at the meeting, the one who is, professionally in your same milieu. I just don't see. As somebody who has been to so many conferences, we're like, this is exactly what you do. Like, oh, that's a familiar face. I don't even really know this person that well, but as opposed to, they're just a little bit different from the sea of strangers otherwise out there. And it's kind of normal to reach out for that connection. And it may not mean anything at all. I may not know anything about this person other than we used to work at the same place or we worked on a case together. So that's where, I just kind of wanted to pause, a little positivist reflection on that. Because I think these rules are still derivative of an era where we had high regard for the judges as the position and expected the highest quality characters to be able to fill that role. And in today's day and age, we may no longer have that assumption. So those rules might seem perhaps a bit anachronistic or inappropriate even because of that. But the solution to that is going to be to change the rules. According to the defendant, a reasonable observer of the video would question whether it is unfair for the undersigned judge to preside over a case involving a colleague who was seen shortly before he was shot and killed. However, as explained above, the resolution of whether a judge's impartiality might reasonably be questioned rests on the perspective of a reasonable observer who is informed of all the surrounding facts and circumstances. The defendant's verified motion does not meet the test of demonstrating facts which would cause a reasonable observer to question my impartiality. Okay, so he got his conclusion. Let's get into his reasoning. We have this footnote down here. Where did this come from? On the other hand, the defendant makes a statement which relates that the video does not create a reasonable inference of partiality. Following the defendant's statement, the fact that these two men served on this very worthwhile committee is not enough to draw an objectively reasonable inference of partiality, the defendant states. However, there will be proffered evidence of bias that contradicts with the presentation seen on the video. Okay, this is what we didn't get to see. The proffered evidence apparently is the undersigned's denial of one of the defendant's motions. As explained below, a denial of a defendant's motion is not evidence of bias. Okay, so this sheds some light on what was that whole, whatever we didn't get to see, seemed like something, offered in camera or whatever. And it's just a ruling. It's just a ruling. Oh, yeah, you guys remember this came up. This came up with Judge Cannoni. You typically do not get to rely on just the fact that a judge is ruling against you as proof of bias. If the judge is acting within their discretion, the judge is following the law, it's not going to be enough. You're going to need at a minimum, some kind of pattern of the judge repeatedly making wrong decisions, flagrantly wrong decisions that are to your detriment, before I think that's even going to be able to be considered. Because the fact that the judge thinks you're wrong isn't establishing bias if there is a basis for the judge to think that. To be sure, Judge Mullins and I shared the legal profession and may in that regard be viewed as colleagues, but our nominal, purely professional association is not the degree of relationship which would interfere with my duty to uphold and apply the law and to perform judicial duties fairly and impartially or suggest an appearance of partiality. This case here explains the relationship continuum and discusses which relationships require recusal. You going to tell us more? Yes. Judges have many extrajudicial relationships, connections, and interactions with any number of persons, lawyers or otherwise, who may have business before the judge and the court over which he or she presides. These relationships may range from mere familiarity to acquaintance to close, intimate friendship to marriage. Not every one of these relationships necessitates a judge's recusal from a case. Recusal is generally required by Canon 3E1 in a proceeding in which the judge's impartiality might reasonably be questioned. Thus, the intensity of a judge's relationships might be viewed on a continuum. On the one side is the judge's complete unfamiliarity with a lawyer, a witness, or a litigant, except in a judicial setting. No recusal is required. On the other extreme is a judge's close personal relationship with a lawyer, a party, or a witness, such as a family member or a spouse. Recusal is required under Canon 3E1. At some point between these two extremes, a judge and a participant in a case may have such a close social relationship that a judge should disclose the relationship to attorneys and parties in a case, and if need be, recuse. It's the gray area in the middle where things always get super tricky, right? The bright lines at the far ends are really clear and obvious, but it's the room in the middle that gets tricky because you don't have a hardline rule that says, okay, he's not your brother, but you've been friends for 20 years. You play poker at his house every Friday night. You guys get drunk together. You talk about, close personal things. There's no bright line rule that says the judge has to recuse in that situation. And so that's the room where the unethical judges have room to play. The rule doesn't say I have to get out and I think I can be fair and yada, yada. And then you're always going to have the fallback of the objective facts that a reviewing court is going to look at and just see if they agree or not. Is it objectively reasonable that this doesn't create a problem for you to be presiding over a case involving your 20-year poker buddy? Probably not. Probably not reasonable. And then just as the facts get murkier and murkier and thinner, you're far more on the side of not seeing anything here that can't potentially just be overcome with new information. Might really, be fine with my neighbor. We've had perfectly pleasant interactions, but then something happens, like I see I see the neighbor beating up the mailman. Is it going to change my opinion, or am I going to still think the neighbor is super nice? And that's going to be different if it's my brother. I'm going to have a pretty fixed opinion on my brother, regardless of whether he beats up the mailman, because I'm going to see that as like, oh, it's an outlier. I'm going to make excuses for it and stuff like that. It was just a bad day. And you're way less inclined to give that kind of that kind of benefit of the doubt to somebody that you don't know as well, that you don't care about as much. So the spectrum, the extremes are super easy. It's the middle that always gets fuzzy. And some parts of the middle are going to be more clear. But now, it's your 20-year friend. You've known him for that long, but you're just on Facebook. You haven't seen each other in person for 20 years. You don't DM. You just comment on each other's pages. Is that going to be enough? Is that the kind of relationship that means you have such a fixed opinion that you're unlikely to change it based on new information? Yeah, I think that's going to be a bit more of a challenge. The defendant cites no authority finding that a professional relationship such as that which existed between Judge Mullins and myself creates an appearance of partiality giving rise to the necessity of recusal, or authority which deals with the recusal of a judge on the grounds that the judge in some way knew the victim in a criminal case. While not factually on point, this other case, abrogated on other grounds by another case, just basically means it had an unrelated proposition of law in it that is no longer good law, is a case in which the trial judge had prior judicial interaction with the victims, we'll come back to this footnote, in a criminal case, and which provides context for evaluating whether a reasonable observer would view the circumstances here as giving rise to an inference of partiality. In Dunlap, the defendant pled guilty to 3 counts each of capital murder, capital kidnapping, and tampering with physical evidence, and 1 count each of attempted murder, first-degree kidnapping, first-degree rape, first-degree arson, and first-degree burglary. Well, that was quite an incident. The victims in the case were Christy Frensley and her 3 children, Kayla, Courtney, and Ethan. Ugly crime. About 1 month before Dunlap's trial was to begin, Dunlap filed a motion for the trial judge to recuse, alleging that the fact the trial judge presided over Christy Frensley's divorce and custody proceedings and signed the final order awarding Christy custody of Ethan approximately 2 weeks before Ethan's murder rendered his impartiality questionable. Pertinently, Dunlap argued that the trial judge's impartiality was questionable because the judge had no doubt established during the pendency of the divorce and custody proceedings relationships with both Jeffrey and Christy Frensley and quite possibly the children involved. That seems like quite an assertion to me. You don't develop relationships with litigants just because they appear in your court. Yeah, you might form opinions about them relative to the issues that you're being asked to decide. But the whole purpose of court is to limit the relevance of what comes in, not hear stuff that isn't pertinent to something that the judge needs to make a ruling on. So it's not really a context where you'd be expected to just kind of generally learn all kinds of things about people. That's frankly really discouraged for the most part. During the hearing on Dunlap's motion, defense counsel further argued, your decision on the custody battle involving Ethan Frensley, in which you denied Jeff Frensley's motion for custody and kept custody with Christy Frensley, that order was entered on October 1st, 2008, roughly 15 days before Ethan Frensley was among the victims in this case. Judge, I don't know if it affected you. I don't see how it could not. You recently, within a matter of weeks, entered a ruling maintaining custody of Ethan with Christy Frensley, and then 2 weeks later, Ethan is murdered in the home of Christy Frensley. I know you, Judge, and I know that it had to affect you. Aren't you now just saying you know the judge so well that you know how he's going to process a case, but this standard also somehow doesn't apply to you? That means your relationship is too close? I don't know. Maybe it does. And someone looking at this case, either from a distance now or in case of a conviction and sentence years down the road, is going to look at that and say, how could he not have some subconscious desire to see Mr. Dunlap convicted? And how could it not have affected his rulings? Well, this is really easy because you don't have a subconscious desire to see the guy convicted unless the guy is guilty. And that depends on the evidence that's presented. Why would anybody have a subconscious desire to see an innocent man convicted? This whole thought process of like a child is dead, and therefore we must punish the person who is sitting at defense counsel table in front of me. I grant there will be plenty of people who do think like that. They just assume the police have the right guy and they wouldn't have charged him and yada yada yada. It does happen that the wrong person gets prosecuted for a whole variety of different reasons. But no, the subconscious desire is to see the guilty person punished to the extent that there is one. And in this particular type of situation, what's going to bother the judge about this scenario is, did I make a mistake? Did I misjudge the situation? Did I do something that prevented me from hearing evidence that might have, alerted me that the children were an unsafe environment? I would imagine this is going to be very much a self-reflective type of bothering him situation if something like this happens. But this logic, yes, I realize some people think like this, but logically as a proposition, meaning everybody must think like that? No. No, I don't buy that at all. After explaining that it is not unusual for litigants to appear before him in different roles, the trial judge responded, yeah, as the person who's had the foster kids turn into the adult criminal clients, very familiar with the different roles of the litigants in court. In your motion, you did talk about a relationship with the Friendsley family, and I don't know what would be the correct term, but the only thing I know about the Friendsleys is what I knew from a couple of days of hearings in that case. I don't know them outside of the courtroom. I don't know any facts about this case from outside this courtroom. So I don't think that it's fair to characterize a sitting judge as having a relationship with parties litigants. I agree with the judge completely on that. I have neither formed nor expressed any opinion concerning the merits of these proceedings. I just don't think that the facts of this case are such that a reasonable person would reasonably question whether I, as the sitting judge, based on a prior case involving the crime victims, could reasonably be expected to be partial towards one side or the other. Judges see the same defendants over and over and over again, too. That's a thing that happens. You see the same defendant and you maybe you cut him a break, you give him a sentence alternative the first time around. Go do X, Y, and Z and do it successfully. It's an opportunity to get your life turned around. And if you do that, then your consequences will be minimized. They'll be lessened. Don't do it, and you'll suffer the full consequence of the law. And then people, fail out of those programs. They don't do it. You still go back in front of the same judge. You don't get a this judge sentenced me to the DOSA that I failed out on. Therefore, he can't be fair towards me. Like, it's just no. It's not how it works. You don't have those types of relationships with the litigants. Now, once again, we're talking principle and the difference between principle and the kind of hard reality world that all this operates in. Because, I tend to think a lot of judges can get real jaded. They can get real jaded and start to lose hope, lose perspective, lose optimism that people really will turn their lives around this time. Sometimes people have to fail a lot before they turn their lives around. Some people will never turn their lives around. You get it all. But I do think there's a real tendency that does happen with some judges that you just see people fuck up over and over and over again so many times that you stop believing they're not going to fuck up. And so you might be a little bit less receptive to new information about positive steps that they're taking to turn things around. I do think this is a real thing. But it's just not what's contemplated in this idea of what being biased is. If anything, it's just I don't know, I guess kind of raising the bar. Judges are expected to know at least a little bit about your history. Like, even if I myself am not the one that sentenced you to the DOSA, which is the drug offender sentencing alternative in Washington. I didn't sentence you to the DOSA that you blew out on, but I have your criminal history. I have to, because I have to base my sentencing decision on that. So I need to know what it is. I'm going to see you blew out a DOSA. Is there something different about me having done that personally versus me looking at it on paper and be like, oh yeah, no surprise. Look how many times this guy's fucked up. Probably going to fuck up again. It's just, it's a mindset that's a problem, but I don't see that it necessarily is a problem that results from this specific situation, having that person as a litigant. It's just from seeing the pattern of people fucking up and not changing their lives over and over and over again gets them a little bit jaded. But it doesn't have anything to do, really. It's not that I see, not that I can think of, with like being the person who cut him the break that didn't work out. The Kentucky Supreme Court concluded, we do not believe that the trial judge presiding over the Friendly's divorce and custody proceedings creates the appearance of bias or calls into question his impartiality. The trial judge had no relationship with the Friendly's outside the prior proceedings, and Ethan did not appear before the court in the custody case, although Kayla briefly appeared as a witness. I do not possess any type of interest which would give rise to an appearance of partiality. As explained in Allred, a great difference exists between mere familiarity of another and acquaintanceships, and those situations with which the law recognizes by their nature carry at least the appearance of partiality. My peripheral contact with Judge Mullins falls on the continuum between mere familiarity and acquaintanceship, a level of relationship which does not generate bias or prejudice against a defendant. I'm going to scoot back now so we can look at this footnote that we missed. American Bar Association formal opinion issued in 2019 provides like guidance for 3 categories of relationships between judges and lawyers or parties to assist judges in evaluating ethical obligations those relationships may create under Rule 2.11 of the Model Code of Judicial Conduct. 1, acquaintanceships, 2, friendships, and 3, close personal relationships. Pertinent to the circumstances here, page 4 states that a judge and a lawyer, and likewise a judge and a party, should be considered acquaintances when their interactions outside court are coincidental or relatively superficial, such as being members of the same place of worship, professional or civic organization, or the like. For example, the judge and the lawyer or party might both attend bar association or other professional meetings. In this type of relationship, generally, neither the judge nor the lawyer or party seeks contact with the other, but they greet each other amicably and are cordial when their lives intersect. Opinion 488 advises, evaluated from the standpoint of a reasonable person fully informed of the facts, a judge's acquaintance with a lawyer or party standing alone is not a reasonable basis for questioning the judge's impartiality. So this is getting into that person I know at the conference. Like, we never hang out. I might not even, I'm the kind of person, I'm so bad with names, I might have to like rack my brain to even remember what their name is, right? But I'm really good with faces. I'll spot the face. I recognize that's a person I know. I'm going to like sit near them. No contact with them. No relationship beyond just, yes, the superficial kind of level of professional engagement. These are acquaintances. So it seems like in this spectrum, acquaintances clearly don't have to recuse. Close personal relationships clearly do have to recuse. It's the friendships in the middle where things get a little bit tricky. It's more than just an acquaintance, but you're not really that close. And I can see that. I can see why that is the situation where it might get a little sticky, and it might just really depend on the facts of that particular case. All right, back down to where we left off. By being an active member of the legal profession for many years and serving in various roles, including Commonwealth attorney and now circuit court judge, I have traveled across the state for court and countless other meetings. I cannot recall a formal or informal, professional or personal interaction with Judge Mullins on any occasion, and the KJCMH video reflects a lack of close relationship. My interaction with Judge Mullins was as limited as it was with the dozens of other members of the KJCMH. Judges throughout the Commonwealth know and are known by many people, some of whom may eventually be the victims of crime. The fact that a judge knows a crime victim through professional practices and organizations does not by itself create the appearance of partiality. A judge is not required to become isolated from society, other judges, or forego participation in professional activities. Indeed, it might be bad if they did. The judges could be so isolated, so removed from ordinary discourse that they lose perspective on the reasonable perspective that's in society. You know, you're so insulated from what other people think that you know, you lose the ability to kind of have a theory of mind of it. That's not really a valuable thing. We just kind of have to trust judges to be tempered in how they apply that in their recognition in themselves of the uncomfortable points. We're like, ooh, maybe I don't want to hear this. Like that should be, I don't like this. This is making me mad, you know? Those types of things should be encouraging you to think to yourself, does that emotional investment suggest perhaps I'm not the right judge for this case? I'm not distant enough from it. The fact that there was no personal relationship at all, or any professional relationship between Judge Mullins and myself, other than us both being members of the KJCMH, would assure a reasonable observer that I would not have a bias in favor of Judge Mullins. Let's go back to this footnote. Although not a Kentucky case, State v. Hubbard, case out of Nebraska from 2004, reflects the same principles applied in Dunlap, but deals with a trial judge knowing the crime victims in a professional capacity. In Hubbard, Hubbard was charged with one count of burglary and being a habitual criminal and another count of theft by receiving stolen property valued at between $500 and $1,500. The victims were two attorneys. On appeal, Hubbard argued that the judge had a conflict of interest because she knew the victims in the case and had attended professional functions where they were present and erred when she did not recuse herself from the case. This would prevent me from ever being able to argue in front of the Washington Supreme Court because I have been to CLEs and other types of, professional. I've served on committees with Washington Supreme Court judges. This would mean, therefore, they can't hear my arguments. That's not the law. Okay, the fact that we've been on a committee does not give them any particularly higher opinion of me. Or worse. Maybe it does. Maybe it does. Just put me in peril. But yeah, not seeing that here. Here, the judge knew the victims in their professional capacities. However, nothing in the record indicates that the victims were close personal friends of the judge or that the judge had a personal interest in their case. That the victims are attorneys known by the judge in her professional capacity is not enough to require recusal. That a judge knows most of the attorneys practicing in his or her district is common. And the fact that a judge knows attorneys through professional practices and organizations does not by itself create the appearance of impropriety. The defendant makes an additional claim in support of my recusal beyond the fact that Judge Mullins and I served on the KJCMH. The defendant asserts that inherent bias from the video would lead an objective observer to believe the undersigned's denial of the motion to unseal the KCPC report was a result of such bias. While the defendant recognizes that a defendant's disagreement with or challenge to a judge's ruling is handled through a proper procedural mechanism, see this quote with a parenthetical quote, the whole idea of our system of justice, especially in appellate proceedings, is to assess a judge's rulings based upon their soundness in the law and reason. Don't like his ruling, you appeal it. Doesn't mean you're kind of putting the cart before the horse. If you're saying I disagree with his ruling, therefore he needs to be disqualified. You got to do it the other way. You got to establish really bad ruling here. And in fact, it's so bad that it tends to indicate he is biased. Okay, I'll give you an example of this that came up in a case that I handled because it was one of the rare situations where a case was, a judge was disqualified on appeal. They sent it back down and said, you need to give this to a different judge. And so this was a case where a defendant who, happens to be pretty Latino in a pretty rural Washington area. He's convicted of I don't even remember some felony. It wasn't like an egregious one. It was something like, attempted burglary or maybe vehicle prowling or just something along those lines. And so he gets convicted. The judge imposes a sentence based on the judge's interpretation of some part of the sentencing guidelines. And his interpretation has been overruled. Washington Supreme Court has already considered this, said, no, we don't agree with that. So he should have known better at the time, but didn't. Imposed a sentence. It goes up on appeal. The court, I was not the attorney on this first appeal. First appellate attorney raises, he adopted this interpretation. It's already been overturned. Need to remand it for resentencing. Court of Appeals agrees, yes, obvious legal error, go back and do it again. Doesn't get disqualified the first time around, but the second time around, when he reiterates his same interpretation that has already been rejected and goes on like this spiel about how he's the trial court judge and he knows so much more than these appellate judges. These appellate judges don't know anything. If they want to figure it out, they can come and get elected, but they wouldn't be able to. Like, says he's kind of like crazy, shocking things about the Court of Appeals that just reversed you. That's when I got the appeal. So this was a case where not only did he get a wrong ruling, but he got a wrong ruling that he'd already been advised was a wrong ruling. And just was like shockingly disrespectful and dismissive of his role in the process, right? Not recognizing and accepting there's kind of a hierarchy here and you don't have the final say on what this stuff means. They do. You have a duty to follow the law. It's literally an oath that you take. So in that situation, yeah, getting the judge disqualified is fairly easy. But once again, it's only after the appellate process, after the reviewing court has seen, not only has he made a wrong ruling, not only has he reiterated this wrong ruling, but he has expressed his bias. He has said outright that, he's not going to follow this because he thinks these appellate judges are dumbasses and nothing is going to change his opinion on that, including binding authority from the high courts. So it can be very frustrating because appeals go very slow and you're always on the back foot. You're at a disadvantage. Just procedurally speaking, the standards are not favorable to the appellant and so forth. So it can be very frustrating to have to do that. I get it. I really do. But that's the only way you're really going to be able to make the case that this ruling, wrong rulings don't mean the judge is biased. It means the judge was wrong. So you need more than just wrong rulings. You need more than just rulings that you think are wrong, but haven't been, found to be wrong by a higher court. And you need more than just a pattern of being wrong, because judges can also be dumb. It does happen. Judges can be dumb without being biased. So you need a pattern. You need something, something more that shows the reason why this is happening. Isn't just the judge is dumb. It's the judge is malicious. The judge is biased. The denial of the motion to unseal, that's the part that we didn't hear before, the proffer. And so I'm very underwhelmed. I'm very underwhelmed by it as an argument that not allowing it to be unsealed when the statute makes it confidential this is an uphill battle. According to the defendant made multiple revelations to the examiner that would conflict with the undersigned's professional knowledge of Judge Mullins. I remember talking about this because we're in this kind of he's paranoid, delusional, crazy, right? Because we're pursuing an insanity defense. He's not in touch with reality, but he's making these statements about Judge Mullins. Are they in touch with reality or not? Are we supposed to be taking these seriously or not? Like, I'm very confused. I'm just very confused about when I am supposed to credit what Mickey Stines has to say and when I'm not. Having a hard time finding the consistency in this argument here. The defendant states that the objective observer would rationally believe that there is inherent bias from the video, and this would lead the undersigned to prohibit the normally admissible KCPC report from coming into evidence. The defendant claims that at this point, there has been no legal basis as support for the denial of the motion to unseal the KCPC report. However, it is well settled that a litigant's disagreement with a court's interpretation of the law or adverse rulings is not a proper basis for recusal. So we have this U.S. Supreme Court case in Liteki. The U.S. Supreme Court focused on 28 U.S.C. 455A, the federal statute governing disqualification, which is substantially similar to the Kentucky statute. The United States Supreme Court explained in its in-depth analysis that performance of the judicial role alone is not a basis for recusal. However, disagreements with judicial rulings may serve as the grounds for an appeal. The court stated, first, judicial rulings alone almost never constitute a valid basis for bias or partiality motion. In and of themselves, i.e., apart from the surrounding comments or accompanying opinion, they can only in the rarest circumstances evidence the degree of favoritism or antagonism required. Almost invariably, they are proper grounds for appeal, not for recusal. It's because you need the why. Judge could just be really dumb. Really dumb. You need a why. So then C. Minks, concluding that the judge who signed the search warrant for the defendant's residence was not required to recuse from the suppression hearing concerning the fruits of that search, when the defendant failed to present any evidence to indicate that the judge harbored a personal bias, had personal knowledge of any disputed evidentiary facts concerning the suppression proceeding, or had expressed any opinions about the merits of the proceedings. Judges don't have to recuse themselves from motions to suppress search warrants that they themselves signed. It may seem like a judge would have an interest in upholding a search warrant that they signed. If you're making a purely legal argument, you're going to be on the back foot with that judge. And so then once again, your remedy is going to be appeal. It's going to be appeal if you think the judge got it wrong. To the extent the defendant suggests otherwise, the trial court's adverse ruling, even if erroneous, does not provide a basis for finding bias. So he doesn't get into at all the statute. We looked at the statute before, and the statute makes it confidential. It can be unsealed, but I'm pretty sure it's discretionary. And frankly, his own description of it, defendant made multiple revelations to the examiner that would conflict with the undersigned's professional knowledge of Judge Mullins. This is self-serving hearsay. He's saying, I want to unseal this report because I want to get the defendant's statements that he made in this context with this motivation to be available for him to use in the bail hearing rather than testifying himself to these same statements. It's kind of what I'm seeing. Can't say that seems like a particularly unreasonable position for the judge to say, nah, you know what? You can just testify to that. You don't need this psychiatric report where you said these things to these persons. Perhaps you have secondary motives. Perhaps you don't. But the easiest way to evaluate that is just going to be to testify yourself. Can't say I think it's unreasonable for him to not unseal the report so that the defendant cannot backdoor his own hearsay. Lastly, Oh, wait, is that where we finished off? The defendant complains that the undersigned did not disclose to the parties that the undersigned and Judge Mullins were both in attendance at the KJCMH meeting, despite the close connection in time to Judge Mullins being shot by the defendant. Rule 2.11 commentary advises that a judge should disclose on the record information that the judge believes the parties or their lawyers might reasonably consider relevant to a possible motion for disqualification, even if the judge believes there is no basis for disqualification. I fully believe that sharing no more than the same area at a professional meeting with dozens of other individuals in attendance, no one would reasonably consider it relevant to a possible motion for disqualification. Well, you underestimate defense counsel. If you expect, and I put myself in this category, you're not there to be a reasonable person. You're there to be an advocate for your client. So if you think it's something that you wanted to know, you're going to see, you're going to see it as reasonable that you want to know that. But it doesn't mean that because you are in that partial position yourself, that somebody who isn't, the objective person, is going to see it that way. Conclusion: for the foregoing reasons, it is hereby ordered that the defendant's verified motion to recuse/disqualify is denied. 6th day of March, 2026. So that is our motion, or our outcome. That's our ruling on the motion to disqualify. So what happens now? He's got time to appeal, probably has to pursue it on an interlocutory appeal. So it's discretionary, not automatic, probably has to ask for permission. But the process is going to be laid out in the Kentucky statutes. It's, I suppose, possible they might have a, avenue for automatic appeal of this type of decision. Don't know. So, but either way, it's going to be an option to him, either discretionary or, if statute makes it automatic or something like that. Typically got 30 days to do that. So by early April, he's got to decide if he wants to appeal this or not. To me, it doesn't look like there's an awful lot to work with here. I mean, if that's our facts, this really is quite nominal. And the whole, the only real connection we've got to any of this anyway, why it would matter if he's got an association with the judge, is that it might affect his evaluation of things that Mickey Stines said about the judge. And it's really not clear. Still, the defense hasn't made it clear. Are these things that he's saying are true that have some kind of bearing on the defense, or are they things that reflect a distorted, psychotic, out of touch with reality type of mental state, which he is asserting for purposes of his defense? So even if there was kind of something here to work with, I just am not really seeing a good argument for why it would inherently make the judge biased against Mickey. I guess maybe the fact that Mickey's on video, we know he shot the judge. So if you like the judge, I guess you're going to have that grudge against Mickey. But once again, your goal is for the guilty to be punished, not the innocent. So if Mickey is innocent, maybe that's me being ideal now. I don't know. Obviously, kind of know not every judge is gonna follow this aspirational standard. But bottom line, yeah, it does not look like a really strong appeal to me. So what that says to me, if he does appeal, either they really want this judge off for some reason. I don't know. I'm not in this community. People have all kinds of different opinions about judges. Maybe he's overly prosecution friendly. Maybe they think he's going to resist motions to suppress, whatever. they might have, some reason to think he's a bad judge for the defense, so therefore we really want him gone. I'm not in a position to kind of evaluate any of that, but it would say that they want him gone more than they want, one, Mickey to have a chance of getting bail and potentially getting released, and two, the case to continue to move forward, because everything at trial will remain stayed. And we're like a couple years into this case already. So it will tell us a lot about the defense priorities if they do. Delay is kind of often a defense strategy. If you're not real confident about what your outcome is going to be, then sometimes just delaying and hoping something will materialize, hoping circumstances will change one way or another. That can, in and of itself, kind of be a defense strategy. And so, it's not automatically an insight into their assessment of the strength of their case. It's just that you do kind of normally expect, if somebody knows they've got a solid defense, it's going to be easy to sell this to the jury, we're going to knock it out of the park. You want to get that presented as soon as possible. Because the sooner you get your win from the jury, the sooner your guy gets out of jail and goes home. So we'll see. We'll see what happens with this one. Guys, not expecting other than the deadline for the appeal process to pass. Otherwise, not really expecting anything to happen in this case in the short term. This one has been the just dragged out kind of ad nauseum for some time. So still not clear if we're getting any closer to trial. Still have the motion to change venue that the state filed that's sitting out there. I had kind of thought maybe the judge will find a way to tie these together, but no. Nope, that is not going to be the resolution. And I guess it makes sense in part because he's already a special judge. He's already a visiting judge. He's not tied to the county. So moving it doesn't necessarily get rid of him anyway. But still got that to deal with, get a trial date set, everything before we can finally start to get some information about what exactly is going on here with the insanity claim. Now, I happen to know that in the meantime, the civil case is supposed to proceed forward to trial. Haven't checked on the status of it. Not unusual, of course, for civil cases to settle at the 11th hour. But to the extent that there is information or background that may affect this case arising out of that one, which does seem to be somewhat connected, at least temporarily. It was Mickey Stines being deposed in connection with his alleged liability in that civil suit. That was kind of the trigger days before the shooting for all of this to happen. It was at the deposition where his attorney is saying, "Oh yeah, he's got this history of California encephalitis. That's why he can't remember things. He has these episodes, these attacks." And describes a disease progress that just doesn't sound much like actual California encephalitis. Yeah, I got a lot of antenna poking up about this one. Things that just don't seem right to me. Just don't know what they mean. It could be somebody is trying to already kind of lay the groundwork for a possible claim like this. But maybe there is some legit psychosis. I just don't know. But I'm really ready to find out anytime. But we're gonna have to continue to wait for the process to unfold. So if I see anything new and interesting about this case or possibly the related civil case as well, I will update us on that and where it takes us. But in the meantime, we keep the same judge, and he may or may not appeal it up to the Supreme Court. We'll see. Doesn't appear to me to have the strongest prospects if he does, but I'll have to evaluate that when it happens. So with that, guys, I will be back next time we have more to say about the Mickey Stines case, and I will see you guys soon.